We're so happy to be here. So glad to see so many of you here. My name is Nina. I'm a lawyer and partner of the Fredersen law firm. And I have Jonas, my colleague, here with me today. He will introduce himself later on. So Fredersen, who are we? We are a law firm, business law firm, founded in Malmö in 2006, so 20 years ago. And we have offices in Malmö and in Stockholm. And we have an office space here at the Novum since a few months back. And we also have an office space at Medicon Village in Lund, which are similar to this life science cluster. We provide qualified business law and focus on maximizing client benefit. And always work in a solution-oriented way, focusing on driving the project forward and helping our clients to maintain focus on their day-to-day business while we focus on the law and structure. We usually say that we have 3 areas of expertise. We work within transactional law, we do dispute resolution, and our third area is a bit broader. It's a business strategy advisory, which is everything else, basically. Transactional law, in this area, we regularly advise clients on M&A and real estate transactions, as well as equity capital markets and public M&A transactions. I will talk a bit more about that later on, since it's my area. We also have colleagues who are great at dispute resolution, in case you would have a dispute with another company or person. They handle all commercial disputes in all stages, from early risk assessment to proceedings in court and also before arbitral tribunals. And the third area, the business strategy advice, we also provide qualified and specialized advice across a wide range of legal, strategic and commercial matters, in a range from commercial law, life science, IP, banking and finance, and all corporate law. As I mentioned, I work mainly with corporate matters and transactional law, which means during springtime, as now, we have a lot of general meetings coming up, shareholder meetings to plan for, such as like incentive programs for the employees, and all other matters that can be great to think about in connection with a general meeting. Our clients are all kind of companies from the early stages, from the formation of the company via the first seedings, potentially an IPO, public listing, and later on following the companies and helping our clients with their day-to-day questions like inside information, handling all kind of market abuse, regulation issues, information to the market, contacts with investors, and so on. Our approach is that we provide tailored business-focused advice from the right specialist at the right time. And yes. Within the transactional law, we also focus and advise on rights issues and private placements. As I mentioned, from the very first seeding and all the way to more complex public M&A transactions, such as rights issues when you're a listed company, and potentially a takeover bid later on in the company's history. Very short about Fredersen. I will leave the microphone to Jonas, who will introduce himself and talk a bit more about life science.
Thank you, Nina. So my name is Jonas Kullgren, and I'm a partner at Fredersen, and I'm head of the IP and life science department. And many of my clients are life science companies, and I typically follow them from early stage as researchers at the university, and all the way until there is a final product that's about to be commercialized. And on that journey, there are many agreements to be signed for the company, as many of you know. And I wanted just to share some key insights that I've made over the years. I worked for 14 years at Fredersen, and before that at Alva. It's called Alva now, before it was Alva Patent. So I think I will just focus on the one that I have framed in red here, but these are the main agreements that you usually come in contact with as a life science company. So it's the assignments. It could be different kinds of assignments, but the first one is from these researchers to a specific company, and then follow this journey to a commercial product. We have, of course, the license agreement. That's the big agreement, and I think that's too big and too complicated just to focus on now when I have 50 minutes. And if there is any agreement that I'd advise you to contact a lawyer, it's for this license agreement. It's very detailed, and it's often the core of the business for many, many years ahead. And we have these, of course, NDAs that I guess all of you have signed in different shapes. The consult agreements, the MSA, and the clinical trial agreement. But as you see here, there are many different kinds of agreements here, and some of them overlap and are about the same. But just to go through some key aspects. And if you don't review the agreements sufficiently, there are some risks, of course, and it's always how you have to prioritize money, how much it costs to review it, and the risks. So hopefully I can share you some aspects here, how to make that judgment. So, but of course, if you don't have sufficient agreements, or some clauses are not there, or if it's too bad for you as a company, it would be difficult to convince investors to invest in you. Because it's too vague and too risky for them. So that's the main point, to have everything in place. And sometimes I think that it's easier just to sign the templates that you get. Often here, this is a template. This is nothing you can do about it. But often there is a possibility to discuss and negotiate some key issues at least. Sometimes and often it's better to focus on that in the beginning, because if we do it afterwards, it would be very costly in terms of internal resources, and if you need to contact a lawyer. And sometimes you see that the agreements are not in place regarding who is the inventors here. So after some years, a student appears, or a co-researcher emerges and want to take part in the agreement, and of course want some money or royalty there. So that it's very important to have the agreements in place regarding that. So I think that it's a good idea to just focus on some special pitfalls that I have come across when reviewing these agreements, and that you can have in your back head when you review it, so you have that with you. And of course, we have these assignments from the beginning, from the investors to the company. And sometimes, as I said, the investors are not identified, and there's no assignment for all of the investors. Sometimes you see that not all the future developments are included, and that could also be a problem. Maybe the researchers start a new product or new project, and maybe that would collide with the projects you have done previously. And sometimes you see that the royalty claims in these agreements are very high compared to to the costs for the entire development. Of course, the researchers want as much paid as possible, but if it's too high, maybe it could be a problem also for them, because it will be difficult to commercialize. Maybe it's my beard. And my skånska. And then we have the NDA. Often there's templates that you get that you think that's just to sign, but there are some key aspects there as well that you need to focus on. Especially if you're a listed company, there needs to be some exceptions there so that you will be able to publish what you need to publish according to stock exchange regulations. And sometimes you see that the counterparty is allowed to share the information with many other parties, but they don't take responsibility if they share the information in their turn. So that you have to focus on as well. And then if you have entered into this agreement, you know this problem. It's the governing law and how to handle disputes. It's very often long discussions about that. So my suggestion is that you have a default setting, and then you have some prepared fallbacks, so you don't start negotiating that from scratch each time. Maybe you can suggest Sweden and SCC, the Swedish arbitration. A next step, for instance, Switzerland and ICC rules, and some jurisdictions you should have as deal breakers, as Texas or something like that. So, but it will save a lot of time to have that prepared. And I also suggest that you have your own templates for that. So if you're starting a negotiation, you be the one who sends your template first. It will save you a lot of time. Consult agreements. Sometimes you see that you enter into agreements with physical persons instead of companies. And that could be a problem from a tax purpose. Sorry. It's important that all IP is transferred in the agreement. Sometimes you see that that's limited in some way, but that's very important for you. And if the consultant has its own IP and that's included in the results, it's important that you get a license to use it. Otherwise, you could be locked in there. And when it comes to MSA, Master Service Agreements, there are many pitfalls. So I didn't just list 3, but 5. And that's the same thing as for consultancy agreement, that if they have their own IP included in the results, and that's not unusual. It's very important to identify it. So often I write in the agreement that they are not allowed to do it unless we accept it, and if they do, if we accept it, we need some kind of license. And sometimes you see that they obtain IP if they make some development, that they keep the IP for that. So that's also important that you can keep it. And sometimes the IP is closely related to their IP, and that we have to have discussion where to draw the line, but it's important to address. And it's often the case that in the agreements they say that they will do anything they can to keep timelines, and that they will try to produce a product that's not deficient. But if they don't do it, there are no sanctions against them. So it's possible to negotiate that as well, especially if the product is deficient. Some problems they can't foresee, and that's okay, that they don't are responsible for that. But if they don't follow the protocol or don't do the study as you had agreed on, I think it's fair that you get compensated in some way. And if you're stuck with a supplier, for instance, and you know that you want to use this supplier later on for commercial purposes, and sometimes you need to use them because for regulatory purposes, or it's too expensive to go to someone else, I think it's a good idea to negotiate those prices when negotiated during the different phases, study phases, because otherwise it could be very, very expensive later on. And then we have the clinical trial agreement, if you enter into such. Also there, you often hear that they are templates and there's nothing you can do, but there is. And the key point there is to handle the IP. That's always the key issue. And every jurisdiction have their own rules. As in Sweden, we have the lärarundantaget, as you probably know about, and you have to handle that separately. So it's important to have a focus on that. And if you have a multi-site study, it's important how to coordinate the publication. So that will be in the same way, and that all sites publish at the same time. And sometimes the site can terminate the study without cause, and that could cause really problems with the timelines and costs and everything. So it's important that if they need to terminate it, it needs to be some specific cause for that, or maybe some compensation to you. So that's the top 3 pitfalls for these agreements. And if I want you to remember anything from this presentation, these are the key points, as I believe are good to have in your back head when we're reviewing agreements and think about. Is that the default should be that you should always keep all the IP in every agreement as a default. Sometimes you have to negotiate, of course. But if you have that as a default, it's easier to find this in the agreement and to make the to share it in a fair way. And as I said, that others' IP is not included in the result, and if it is, you have to know about it and you have to get a license. And of course, confidentiality is very important to protect your business and to protect inventions that not have been patented yet. Fixed prices and timelines are important. Often you see that it's estimates, and if it's possible, you should avoid that. And no lock-ins for costs. I think it's good if you can to negotiate prices for the entire phase until a commercialized product. Limitations in liability, that's always important, so you don't face enormous compensation claims. That's also a thing that one often discusses in these agreements. And I suggest that you have, as I said, fallbacks for laws and disputes in advance, so that you don't get stuck on these issues when negotiating the agreements. And I also suggest that you have your own templates, at least for NDAs, MSA, and consulting agreements that you use. It will save a lot of time and it will be a lot safer. Sometimes it doesn't work because the other party is too big or request that you use their template, but at least try to get them to use your template. And of course, you could also send it over to your lawyer to just make a sanity check. It hasn't to be reviewed in every detail, but some key aspects could be looked at. And of course, we are there if you want to reach out, and we will be happy to help you. So this was a very quick insights into the world of agreements in the life science sector. So I'll hand over the mic to my colleague again.
Thank you. Clearly a lot to think about in life science agreements, which I'm sure you already knew, some of them at least. And as I mentioned earlier, we have offices in Malmö and Stockholm, and we specifically have an office space here at the park at Novum. And we're here every Wednesday, sometimes other days too, and we would love to meet some of our new neighbors here. Some of you we already know and work closely with, but we would love to work closer with all of you here at Novum. So if you have any kind of legal questions that you think we could help you with, please feel free to grab us later on or contact us and just to discuss maybe for half an hour your legal issues and how we could help you with these, or come have a coffee with us just to get to know us. Thank you so much for listening today.